Mr. Lewis.
My Lords, just before the short adjournment, we were dealing with the routes to certification for Karen Atkinson. And can I say that we maintain one of the primary routes is that she was properly authenticated by Lister Blake. And can I just show your Lordships a page we do rely upon, which is at page 30 of the bundle. This is Colin Powell's Department of State, and over the page at 31 we have the Attorney General John Ashcroft, and it's important to note on that where he says he certifies that Lister Blake, whose name is signed on the accompanying paper, is now, was at the time of signing, the same Associate Director, Office of International Affairs, Criminal Revision, Department of Justice. And then these words, duly commissioned and qualified. So the words and qualified, we say, are sufficient to make it appear that she is qualified to certify. If it appears that she is qualified or entitled to certify, that satisfies the requirement of purport within the section. So we do rely upon those words, because saying that she is qualified to certify in our respectful submission should be enough in order to show that she at least purports to be qualified to certify. So that then deals with the prima facie case. The other requirements for the magistrate, namely that it's an extradition offence, are also dealt with in the affidavit of Karen Atkinson. We've looked at those and I won't turn them up, but just for my Lord's notes, we've got page 41 at paragraph 17 and 42, page 42 at paragraph 18, and page 53 at item 3, which all show that the conduct carries more than 20 years imprisonment. Your Lordships have already seen that her affidavit was sworn in front of a judge, and we regard that as sufficient certification. And for your Lordships note, that's page 54. And we also say that her overall affidavit, which contains both her testimony and the exhibits, was certified by Lister Blake, who was said to be qualified by John Ashcroft. And our final point, and the point which my Lord Stevens put to my learned friend about it being received in proceedings, it does satisfy in our respectful submission, section 41B and section 14.3B on those respectively pages 1727 and 1728 in the electronic bundle, because there were proceedings in front of the judge in which the affidavit and exhibits were sworn. And by parity of reasoning, over here, if we have mutual assistance requests and other matters, those themselves are deemed to be proceedings. And therefore, these affidavits were, we would respectfully say, sworn in proceedings. Finally, on extradition offence, we say we have an unanswerable point that there is a certificate made by the Minister of Foreign Affairs. Your Lordships have already seen the statutory provisions. Section 14.5 deems that to be admissible if it is such a certificate. The certificate is pursuant to Section 8, and it's specifically dealt with in Section 5.3, and for your Lordship's note, that's page 1716. So all those certificate, and the certificate itself, with the authority to proceed, needs no magic. It simply expressly states that these are extradition offences, and your Lordships have already seen that at page 16 of the bundle. I won't trespass on the court's patience by repetition. So we do say all that adds to the point that there's conclusive evidence these are extradition offences. Could I just very briefly turn to how the matter was dealt with below, because it is informative. And it is important to remember that this issue was not raised before the magistrate. Can I show your lordship how it was dealt with? If we go to page 165 in the first volume, we see the respondent's submissions at the close of the evidence. That is a 45-page written submission document put before the magistrate by Mr. Keir Starmer, as he then was. And nowhere in those 45 pages of extensive submissions is there any inkling of a challenge to authentication. If we go further on in that bundle to page 200, electronic bundle to page 216, you'll see on page 216 that the specific issue was dealt with in front of the magistrate. Page 216, transcript page 162, between lines 4 down, one can see the court is dealing with the certificate of John Ashcroft, and then at lines 12 to 16, the certificate of Lister Rake, and then at 18, the prosecutor, Mr. Cumberbatch, says, and now go to the affidavit of Karen Atkinson. I seek to tender that. And Mr. Starmer says, Your Worship, objection is taken to that document for reasons I'll develop. And he briefly then says at lines 30 to 31 on 216 that he's taking objection to hearsay evidence within the document. So the court clarifies whether he's objecting to the admission of a document. And at page 217 at line 4, Mr. Starmer specifically tells the court he is not objecting to the document. The court says, other than the contents of the affidavit, do you have any objection to the affidavit itself, not of the document? And he then explains at line 8, I wish to object on the basis of hearsay. He's taking the point that that there are some parts in the documents she produced which contain hearsay evidence. There is no argument about due authentication. And at line 28, the court admits and exhibits the affidavit of Karen Atkinson. So at page 310, the matter is put again. So electronic bundle 310. What Mr. Starmer does is he sets out his objection, and I won't ask your lordships to read it, but in short, he's simply saying that authenticated documents don't mean that the entire evidence goes in. It means it's receivable, but subject to exclusion of any hearsay parts. With that submission, we agree. There's a long line of English cases which deal with that. And I'm sorry.
What line is that, Mr. Lewis? What line on 310?
23. I see my Lord Legate has a question.
You're pointing out that no objection was taken to it at the time, but when I discussed this with Mr. Fitzgerald, it seems that you hadn't taken any objection to the fact that no objection was taken to it at the time. So
the way
it was a point that you might have said, well, it's not open to you to rely on this, but you never objected at the time. But you haven't said that, as far as I understand it. So this then becomes a purely forensic point. Oh, well, you didn't make it then. So it can't be a good point. It isn't much good.
My lord is right. Say that this isn't really a pure jurisdiction point. It's a mixed point of law and fact, because whether something is admissible is a matter of fact, and whether or not it purports to be.
Surely it's a matter of law whether it's admissible.
Of course, Molly, it's a matter of law whether it's admissible, but it's based upon the fact of whether or not it's duly authenticated. So there is. Well, my lord's got the point. I won't labour it, but we do, and I know it's been collected.
Well, no, I haven't got the point. I don't know what the relevance is. What is the relevance of the fact that no objection was taken as a matter of law, as opposed to jury
What I
advocacy.
can't do, my lord, as a matter of normal procedure, is store up any points to take them on appeal. You should bring forward any points you can at first instance, because it could easily have been remedied at first instance. And therefore, not to take the point, and in fact, effectively concede in front of the magistrate. And it's a concession by counsel when she asks if you object to the document. No, that is a concession made. It's not simply a point not taken. So it goes further in our respectful submission than simply saying we end up with a waiver of a waiver. The point wasn't taken, it was expressly conceded, and it would be wrong to allow a point such as that, a factual point, to be taken on appeal.
Sorry, is your point then that it was there's a concession which hasn't been withdrawn, or I haven't followed the legal reasoning exactly? I mean, on a criminal appeal, it goes to whether, even if the point's a good one, admissibility of evidence, it affects the validity of the conviction or the safeness of the conviction. And you might say, well, in that context, if there was no objection at the time, that's a relevant factor, but that doesn't apply here. So what's the legal proposition that you're pounding this document on?
I think I'd put it in this way, that there was a formal concession. And that's once you've made a concession, that's the end of it.
Unless you can withdraw it?
Yes.
I mean, normally the court can give you permission to withdraw a concession.
It's not withdrawing a concession as to law, it's withdrawing a concession as to fact. Because if it's conceded she was entitled to certify, that's a matter of fact. And therefore, it's not a concession as to law, which can easily be either withdrawn or changed. My Lord Stevens has a point.
That's a proposition advanced without a single authority to support it.
Yes, my Lord. It is.
It's a matter of law anyway, isn't it? It is a matter of law. I can't say it's a matter of fact. If you concede admissibility of something, that is a legal concession. There's no facts being admitted there. The question is whether she fulfills the requirements of the Act.
Well, my Lord, the highest I can put it then is it's a matter of mixed law, in fact. But I don't think the case isn't going to turn on it. So if it's necessary, I don't rely on the point particularly. I'd simply show your lordships how it was dealt with and how it arose. But it certainly doesn't turn or change my primary submissions. So, my Lord, it was also dealt with in the court. I'll simply give my lords the references then, if you need it, rather than develop any argument on it. It was dealt with in the Supreme Court. That's page 1666 at paragraph 42. And we deal with it in our written case in the Court of Appeal, which is electronic page 1491, and in our written case 1667 at paragraphs 44 to 50. So, my Lord, we say factually, any of those routes are sufficient to make the evidence on both those points, prima facie case and extradition offence, properly admissible. If I were to be wrong on all of that, my final long stop, this is a case where I seem to have a number of long stops, is the statutory construction point. The statutory construction point, I don't know if your lordships want me to develop that in any detail, but if I can just explain it to my lords. If we look at the provision under section 14.3, which we have in tab 3 of the authorities bundle at electronic page 1728. It's, in my respectful submission, important just to understand the legislative history, we've looked at Section 15 of the 1870 Act and Section 11 of the 1967 Fugitive Offenders Act, which dealt with extradition procedures prior to the passing of this Extradition Act in the Bahamas in 1994. Your Lordships will have seen that in both cases, in fact, they seem to have drawn more heavily on the Fugitive Offenders Act provision than they have from the 1870 foreign states extradition. But in both cases, it's absolutely clear that an officer of the foreign state or officer of the country or dependency in question was sufficient to certify. It appears, my learned friend says, looking at the plain words of the section we have in 14.3, that the draftsman changed the position from what was previously available. And it seems strange that he would so radically change the position when there were extant extradition proceedings and treaty partners. It can be read in a purposive way in order to make Section 14.3 apply to both officers of the court or officers of the approved state in question. You can do that in different linguistic ways. In fact, if one simply took out the word in, it would read officer of the court or of the approved state. Now, I'm not quite sure why the word in appears. It does appear in Section 11 of the 1967 Act, and appears to be almost surplusage if one looked at Section 11.2a of the 1967 Act. One can see it says judge or magistrate or officer in or of the country. It's not the clearest linguistic approach to the section. Alternatively, what one could read in our Act under Section 14.3, you could read officer of the court in, comma, or of the approved state, both of which would give a purposive construction allowing either an officer of the court, judge, magistrate, or officer of the court, or officer of the foreign state. There is no dispute in this particular case that Lister Brake is an officer of the foreign state. We say she is also an officer of the court, but it's quite clear she purports to be an officer of state. So, my Lord, if we're driven to it, my Lord Legate.
Apart from the fact that you need to pretend that words aren't there in the statute and that sort of thing, what about the next words? Or officer of the diplomatic or consular service of the state? What are they doing there if any officer of the state is good to certify anyway?
The best I can do, my Lord, is say it's for an abundance of caution. But I accept it's a difficult, it is slightly strange on the face of it, why the draftsman has dealt with it in this way. But if we take, and again, I haven't cited authority, but I think it's a well-known proposition, that if a construction can be found which advances our treaty obligations or advances extradition, one would attempt to see if a construction such as that is possible. And in these circumstances, a construction which includes or removes the word in or puts a comma in after of would be sufficient to allow and ease the machinery and working of the extradition arrangements. But my Lord, as I say, that point only arises if you were against me on all the points in relation to certification by the other routes. So in other words, that would be my final stop on the authentication point. Could I then just turn to the second issue, and I'll deal with it relatively briefly, if I may. My learned friend dealt with it relatively briefly. We first of all accept it is undoubtedly a sorry state of affairs that this matter has taken so long to reach a position where it can be finally resolved. However, there are findings of fact which we say your lordships should be slow to interfere with. Those findings of fact are within the judgment of the Supreme Court and the Court of Appeal. Again, I know your lordships sort of glanced at those. If I can just give the references to the findings of fact. We have in the Supreme Court electronic bundle 1312 at paragraph 22. And in the Court of Appeal, electronic bundle 1499 to page 1504, paragraphs effectively 17 to 39 and paragraphs 42 to 47. If I could just trespass on the court's patience just to show you one or two of those paragraphs in 42 to 47. So if we go to that position, it's in volume 4 for my learned friend's reference. And at page 1499 begins the Court of Appeal's recitation of the facts. But it's important to note at page 1504 that the findings are set out in paragraphs 42 to 46. And this is before they deal with the section 11.3 argument as an alternative remedy. And at 46, the Court of Appeal said, in the premises, I agree with the learned judge's findings that the delay was not attributable to the failings of the Supreme Court registry, but due to the appellant's contentment with the delay as evidenced by their failure to pursue timorously their applications for habeas corpus. Now, your lordships will appreciate they're all on bail in the Bahamas. The further question raised by these grounds is whether in any event, and given the delay of 14 years, it would be unjust or oppressive. So with that finding of fact, it is, again, we say, very close to the position the board has taken in the case of Fuller. And can I just take my lords to that? And simply, it's at page 1876, it begins. It's, for my learned friend, it's Authorities Bundle 1, tab 13, page 1876. And a similar, your lordship will notice that the cast is in fact the same as appears before your lordship's board today by way of advocates. Although it is some 11 years ago, things haven't changed that much. And if we go to page 1903, at paragraph 79, your lordship's board said, in the present case, there was a period of inertia of nearly 6 years after the filing the appellant's notice of appeal. The first thing that should have happened but did not happen was the preparation of the record by the registry. No explanation has been given as to why this did not happen. But the board considers it significant that what was delayed was the appellant's appeal against the judgment of the Supreme Court. Had the appellant wished to progress this appeal, he could and should have made representations to the registry. The fact that he did not do so indicates that, perhaps not unsurprisingly, he was only too happy the hearing of his appeal should be delayed. In the circumstances, the board does not consider it arguable that justice demands the extradition proceedings should be abandoned because of the delay that has occurred. So whether or not there is a freestanding right under the Constitution, we would say your lordship should resist the submission of my learned friend that it requires discharge, or indeed any declaration that there has been a breach of a constitutional right. And in any event, as I think was put to my learned friend by my Lord Lloyd Jones, the alternative remedy here was clearly set out and dealt with in delay. The answer that my learned friend gave was, well, this is a different type of delay because it only goes from the time the court was seized with it to the date of extradition. In our respectful submission is no answer, because that time period is logically subsumed in the overall period one would deal with under section 11.3, which is the delay period. That period goes from the date of offence to the date of the extradition determination, whether it be in the Supreme Court or the Court of Appeal, or this court, or this before this board. So that is the overall period. The learned friend complains of a smaller subset of that delay, which is from when the court should have, and he says the requesting case should have chivied the case on. So in any event, it being a subset of the overall delay, it's already been dealt with by way of the alternative remedy under section 11.3. So my lords, that deals with it, the submissions I would wish to make on the second issue. And unless there is, my Lord Legate.
Is there anything in the Article 6 cases on delay that addresses whether your right to a hearing in a reasonable time is affected if you do nothing about it?
My Lord, there are. Article 6 does not apply to extradition. Full stop.
No, I know, but just for analogy. For analogy.
For analogy.
With the constitutional argument, because it's rather similar. There's a whole case law, isn't there, on the right to hearing in a reasonable time.
And the current case law in the United Kingdom requires there to be demonstrable prejudice before there would be a breach.
Right.
I think the Strasbourg court in Scopalice against Italy said that it wasn't a sufficient answer to an Article 6 complaint to just say that it was up to the litigants to press it on. I think you'll find that in paragraph 25.
I'm grateful, Lord. The Italian cases in the European Court perhaps even shock us in common law jurisdictions. I think the maximum delay in one of the Italian cases was 51 years. But I accept, this is not without, there should have been some movement. It's clear there should have been movement. The matter before your lordship's board, in fact, has taken 3 years, I think. In an ideal world,
what's the reason for that?
I have no idea.
Is that the court's fault? Is it?
I certainly wouldn't be so impertinent as to suggest it was the board's fault, but it is a fact that some of these cases do take a long time. In the particular case, there were the other appellants withdrew, and there was some delay, I think, occasioned by the withdrawal of the other appellants, even after permission had been granted for them to appeal to your lordship's board.
My understanding, and I'm not an expert on it, but is that under Article 6, it's no answer to say, well, it was up to the state, up to the individual litigant to press on. There would still be a breach of Article 6 if the court didn't get the matter to a conclusion. But
I think that's right. Of course, Article 6 doesn't apply because this isn't a final hearing. My learned friend will no doubt say that under the unpronounceable name, Majesty case, that for a resident there is a common law right not to be removed under the jurisdiction, and that should be heard under Article 6.1. But that case is very far removed from these type of circumstances. And there is here, we do say, a proper alternative remedy under Section 11.3 of the Act, which deals with the matter and allows proper redress to be given.
How does the Constitution sit with the propositions in CACIS that delay on the part of the requesting state isn't to be judged as culpable or not culpable, but rather it's only the effect of it? Whereas if it is delay on the part of the fugitive by fleeing the country, then he's got no one else to blame but himself.
Certainly Lord Diplock's dicta in Carcass has moved along somewhat. The Lordship's Board in another Knowles case clarified the way in which it should be in the Section 11.3 jurisdiction should be approached. Of course, I think Lord Diplock described it as a cradle of circumstances. So your Lordship is right, and it may be that Lord Diplock was seeking to spare any diplomatic embarrassment by blaming the foreign state for the delay, and simply said that one just takes all the circumstances into account. And he quoted the cradle of events which have occurred since the offences were first committed. So, Lord, I'm not sure if I properly answered my Lord's question with another question, but I'm not sure if I can improve upon the answer.
Thank you, Mr. Lewis. I don't think there are any further questions for you. Thank you. Mr. Fitzgerald.
Oh, yes. Yes. I'm unmuted now, my lord.
You are unmuted.
Oh, yes. Okay. Thank you. Yes. My lords. Well, can I just try and take the points one at a go? Firstly, my learned friend relied on the judge certifying when it was sworn before the judge, and effectively that was authentication. But the judge's signature does not declare whether it's a copy or an original. The judge just simply says this has been subscribed in my presence. So I respectfully submit that point by my learned friend is not an answer, and I respectfully adopt what my Lord Stevens put to my learned friend in relation to that. He then took the position that Karen Atkinson, in that part of her declaration that uses the language of certification of the exhibits, provides a certificate. I think the court has our submission that if the Karen Atkinson declaration, so affidavit, is not authenticated, then the exhibits there too are not authenticated, and we deal with that in our reply. My learned friend then had a series of alternative modes whereby it could be said that there was authentication of Karen Atkinson, and we do deal with those in our reply at 2.4 at pages 2232. And so can I just remind the board respectfully of those points, that to the extent that he relies on the US Secretary of State, that's to say Colin Powell, he only purports to certify that the document hereunto annexed is under the seal of the Department of Justice, as entitled to full faith and credit. So he's performing the extra bit, and in any event the seal, rather than performing the 14.3 A exercise. As to the US Attorney General, the US Attorney General only purports to certify that Lister Blake is duly commissioned and qualified. Now, my learned friend said, well, it must be duly commissioned and qualified to perform this task, but the function that the Attorney General is certifying that she has is as Assistant Director in the Criminal Division of the Department of Justice, and just simply saying that she's duly commissioned and qualified for that. And to the extent that my learned friend is saying, well, of course, the Americans would expect it to be sufficient for the person to be an officer of the state, because that's what historically was enough under the 1870 Act and the 1967 Act. That fits in with, that's all that is dealt with, is duly commissioned and qualified as an officer of the state. So we say this doesn't satisfy the requirements of section 14.3a. He then, in relation to Lister Blake, he relies on Lister Blake, but there we take our point about that she is not an officer of the court, and just to the extent that my learned friend tried to say, well, that could be given an interpretation whereby they're an officer of the court or they're an officer of the state. We simply say that's not what the words themselves say. There is a noticeable change in the statutory language from the formulation used in the 1870 Act and the 1967 Act to this. And as my Lord Legate pointed out, it wouldn't make any sense to then go on and say, or the diplomatic service, because you would have covered that already on my learned friend's interpretation by officer of the state, of the approved state. So we say that Lister Blake can't do it, and then Judge Vitunak only purports to confirm that Karen Atkinson's affidavit was subscribed and sworn before her. She cannot say that the version of Karen Atkinson's affidavit provided in the extradition request is the original affidavit. She has no idea what document is going to be produced in the extradition proceedings. So that's really our response to each of my learned friend's alternative routes. Now, as to the 14.1b of my learned friend, that is a document duly authenticated which purports to have been received in. What we say in relation to that is, and there were grand jury proceedings, and those are referred to in Karen Atkinson's affidavit, but they were over. So this wasn't an extension of the grand jury proceedings, because she's saying there have been grand jury proceedings, not that they're ongoing. The only proceedings are the prospective proceedings in the Bahamas. There's no proceedings in extradition taking place in America. There is just simply an exercise of subscribing the document for use in proceedings. And it's exactly the same here. We don't have any preliminary proceedings in England when we're seeking the extradition abroad. There's no, as it were, we've got these extradition proceedings before in England, and then those proceedings are continued in extradition. This belongs to the executive phase, as my learned friend would say. So we say that.
Fitzgerald, there's a question.
I'm so sorry, my Lord. Yes, so sorry. Yes.
I may have misread 3B, Mr. Fitzgerald, but doesn't it just lead you back to 3A anyway? Because it says the document purports to be certified as aforesaid.
Yes. Yeah, that's 14.3B. Yes.
Yes.
Yes, my lord. Yeah, I was looking at 14.1b, but yes, I certainly adopt that in relation to 14.3b. Yes.
I mean, I'm very reluctant to suggest a point that helps you on this technical argument, but it seems to me that in this case that there may be.
My lord, I am grateful for any assistance I can derive from any of your lordships, and would welcome any more suggestions. but my lord, joking apart, I do think that is I think that is the answer. I simply don't respectfully accept that the 14.1b or 14.3b solution is available, and it's purely made with a view to these proceedings. Now, I don't know whether I need to deal with the point about why it wasn't taken before. My learned friend somewhat made a tactical withdrawal in relation to that, but I would respectfully submit that there is authority, that a point of admissibility is a point which, whether or not it's taken by any of the parties, should be taken by the judge, and that in any event it would go to the admissibility of the document. And if the document's not admissible, it's not admissible. And even if the point isn't taken until habeas corpus, after all, what are you doing in habeas corpus but saying my detention now is unlawful because the necessary preconditions for lawful detention haven't been made out? And this point was fairly and squarely taken, and we can see a reply to the point before Mr. Justice Isaacs in writing from the state in the supplementary submissions, where they say, with regard to this point, it's a bad point. I think, can I just get the, it's I think it's EB 1272 at paragraph 2, where they're definitely the point has been taken and it's been responded to in writing by the requesting state. Is it 1274? 1274 paragraph 2. Then Karen Atkinson, my learned friend, said, well, she certainly freestanding a source of law on the grounds that it's received in the proceedings. I respectfully submit that she can only give evidence of foreign law as an expert, and she is the only source of that expert evidence as to foreign law. If her affidavit is not duly authenticated, then there is no evidence to provide those matters a source of law. My lords, that goes obviously to the need to fulfil the requirement set out in the treaty and incorporated into the Act that it's got to attract a sentence of 1 year or more. I do maintain respectfully my submission that it would also be necessary under Section 7 to establish that there was no limitation of objection, because after all, that's something that the requesting state is peculiarly placed to deal with. And so I do say in that regard, whether the negativing that it's statute barred is a matter on which the onus is on the requesting state, and that is different from 7.1a b(c). The onus is on them. My lords, that 5.3, I think I've dealt with as best I can, and we've set it out in our reply, our response to the point about 5.3. And if I can just refer you to that in our reply, but oh yes, it's at 3.4 at page 2234. And we do submit that it's got to be set out for the purposes of the Act. And then, yes, I think the rest of it was the point. There were a number of points about how it was dealt with below, which I think that the court has well in mind our response. It's a question of law. There's no evidence. Yes, I think the principle my learned friend, if anything, was referring to is there is a doctrine of abuse in cases such as Osman and in a case called Tarling, that what you can't do is, as it were, hold back a point and then deploy it at a later stage. But there's no suggestion that Mr. Starmer was holding back the point and saying, haha, we'll concede it here and then take it in the Supreme Court when it's too late. It's quite clear that he made a good faith concession on his understanding of the law, and that then a different lawyer, Mr. Gomez, took the point in the Supreme Court and took it, and it was dealt with. And at no stage has it been said that it couldn't be taken. The point of the history, my learned friend's point from the history, which I think, as I understand it, is they really meant to say officer of the foreign state, but they just made a slip up and said officer of the court instead. That, as my Lord Legate pointed out, doesn't really work, because then why do you then have officer or officer of the approved state, officer of the diplomatic corps or consular service? That would have already been comprehended by officer of the state. And we do say, there's the friend was saying, you must adopt an interpretation that advances extradition. That is an alarming proposition to interpretation, that you just, as it were, adopt an interpretation of the statute that makes sure that the person goes back, irrespective of what the language of the statute is. There's no such doctrine, and indeed, if we look at Shooter, it's exactly the opposite. It's that they must strictly prove, because it's a criminal context in which the liberty of the subject is at stake, in accordance with the requirements of the law. So there's no notion that you can just relax statutory construction in order to make sure that alleged criminals are extradited. And really, those are my respectful submissions, my Lord, on that point. Can I briefly reply on delay in the Constitution?
Yes.
So, my Lords, firstly, can I address the lex specialis argument? If one looks at the protection under section 11, this is a protection where the mechanism for the protection is habeas corpus, C 11.1. And the content of the protection at 11.3 is by reason of the passage of time he is alleged to have committed the offence. But where the very mechanism which is supposed to provide this protection is itself the subject of unconscionable delay, i.e. the habeas corpus proceedings. Now, it is right that you could say that because you've taken so long on the habeas corpus proceedings, I want to throw in all the time in those proceedings as part of my 11.3b complaint. You can do that, but that's not a lex specialis argument. The constitutional protection is, if you've got a protection like habeas corpus, you're entitled to have that decided swiftly. And I think my learned friend did back off from the suggestion that there's no Article 6 rights in extradition. Pomachowski, which we've cited in the case, is authority for the exact opposite. In fact, the whole point about Pomachowski was it was a breakthrough. Before that, it was thought that Article 6 did not apply to extradition proceedings. In Pomachowski, it said, well, if you are a citizen of the country from which you're being extradited, it may not be a determination of a criminal charge, but it is a determination of your civil rights and obligations, because no power on earth can remove a British citizen from their country, saved by, etc., etc. The rhetoric of the right to remain as a citizen. So it is an interference with your civil rights, and extradition proceedings, according to Lord Manson and Baroness Hale in Pomachowski, and indeed the whole Supreme Court, does attract Article 6 safeguards. It's just the Article 6 safeguards of the determination of your civil rights and obligations. Therefore, Article 6 does apply to extradition, although it's Article 6 civil. Then the question is has it been determined speedily? And our respectful submission is just look at that chronology between 2008 and 2015, which has got nothing to do with whether they should have said, okay, we'll go ahead with the photocopies, with the rough copies rather than the certified copies. That delay is the prosecution writing into the court saying, Mr. Gomez and I are ready to go in 2010. And the court switching it, I think, between three different judges and not determining the issue. And so we do respectfully submit that that was a delay. And I do apologise that we didn't refer the court to Scopadici, but there is clear authority that you can't just say, well, they didn't insist on their rights, but nearer to home, the whole Pratt and Morgan Henfield, which is in the bundle jurisprudence, is based on the concept that you can't expect someone to hasten on their fate. It's natural that someone who's facing extradition to America to face a long sentence is not going to be rushing to embrace extradition. But if at the end of the day they were perfectly prepared in 2010 to have the hearing, and Mr. Gomez is saying, I'm available, and nothing happens until 2015, and then actually quite legitimately they say, well, let's get the proper record, and that delays things, that and other things delay it for another year. We do respectfully submit that that wasn't determined speedily. So, my lords, I of course I accept that when it comes to the question of remedy, the court would be entitled to look at the public policy considerations underlying the decision in Fuller. But I do submit it's a separate test and a separate question of remedy. And we say that in Dharmalingam, they said that the remedy for delay in the determination of your rights may be to quash the conviction altogether. And in Henfield, they said it's not good enough just to stop the breach and have the hearing. You may have to have the death penalty set aside. Here too, we say, because constitutional remedies are infinitely flexible, that the appropriate remedy may be to, is in our respectful submission, to stop the extradition altogether. Those are my lord. Those are my respectful submissions.
Thank you, Mr. Fitzgerald. Are there any questions? I don't think so. Well, we're very grateful to counsel for their submissions, and we're grateful too to those sitting just out of camera range who have assisted in the preparation of the case. We will take time to consider the advice which we will tender to Her Majesty, and the court is now adjourned. Thank you very much.